Is the case against Alec Baldwin being dismissed? His attorney says yes. Alec Murdaugh wants out of protective custody. No court today for Letica Stauch. That's good after yesterday. Lori Vallow update. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. You know the drill. Subscribe if you haven't, like if you do, leave me a message and hit that little bell for notifications. And remember, you can listen to us on any of your favorite podcasting apps. All right, my name is Scott Reich, and this is Crime Talk. Thanks for joining us. We are back in the studio today. Yesterday, we took a little trip, went out to Ada County, Idaho, to watch the Lori Vallow trial. Interesting to say the least. As I noted, I was in the overflow section, and in fact, I have my commemorative little sticker for getting in. I will always cherish this. Well, not really. Anyway, let's get to the docket for April 20th of 2023. So let's go ahead and open the record. First, Alec Baldwin, is his case getting dismissed? Well, it appears so. Criminal charges against Alec Baldwin are expected to be dropped regarding the October 2021 fatal shooting on the Rust cinematographer Helena Hutchins, according to Baldwin's attorney. Apparently, new evidence has come to light to actually say that the firearm could have just gone off. Color me suspicious that the gun just went off, but I think the prosecution was looking for any way to dump the case, so blame it on the firearm. Next, Alec Murdaugh doesn't want to be in protective custody. That's right. Alec Murdaugh, who we all know is serving 2 life sentences in a South Carolina maximum security prison. Well, he's been in protective custody since his arrival, and he wants to go back to general population despite the threats from other inmates. Now, can you believe it's only been 6 weeks since he was convicted of shooting his wife and son to death back in June of 2021? Literally, doesn't it just seem like yesterday? Well, seriously, he is convicted of murder, and, it's not like he was there diddling kids. He'll be fine. As his attorney said in an interview, hey, he was able to adjust quite well in county jail. He should be able to do well in prison. And apparently Mr. Murdaugh believes that he can, contribute to the population there at the prison, while the appellate courts decide whether there were any legal errors that made his trial unfair and resulted in could warrant a new trial, I guess is really the way I want to say it. So we've thought of a few classes that maybe Mr. Murdaugh could help with. Obviously, since he's an educated man, he's been to law school. He can help others out, for classes, trying to get their GED, obviously. Maybe he could teach a class or two on, creating an alibi. Maybe some classes on social media timestamps. People often say when they go to prison, they don't go to prison. They go to college for criminals. So let's enter them into a master's course. How about a couple of courses on working closely with your banker to get those good terms on lending? How about some ethics classes? And finally, how to lie and not get caught? Well, maybe one more. How about crime scene investigation? How to control the legal system in your county for over 100 years? Just a couple of suggestions there. Now, if you think of any other classes that maybe Alec Murdaugh could teach while he's being released to general population, put them in the comment below. Tomorrow, maybe we'll read a couple of the good ones. Next on the docket, Letica Stauch has no court today, but yesterday was another bad day for her in court. On Wednesday, an FBI special agent testified that the stepmother of Gannon Stauch tried to pin her stepson's disappearance on a wanted sex offender whose unrelated case was quite public in the news at that time. In truth, however, there was no indication that this man, Quincy Brown, had anything to do with the disappearance of Gannon Stauch, who went missing on January 27th of 2020. Yeah, apparently that guy was not even in the country at the time. And, hey, just saying, trying to pin a kidnapping homicide on another person, I think that's frowned upon in most societies. And I think it really just kind of shows you what kind of horrible person you, well, could possibly be seen as. So as we know, Letica Stauch has admitted through her plea of not guilty by reason of insanity that she stabbed Gannon 18 times, shot him in the head once, missed twice, and then cleaned up the crime scene and moved his body in a suitcase to Pensacola, Florida, where she pushed the remains over a bridge, of course, in a suitcase. This all took place while Father Al Stauch was out of town doing drill duty for the National Guard. And it wasn't until bridge workers encountered a suitcase of Gannon's remains that they were found back on March 17th of 2020. Now, the defense asserts that Letica was insane, suffering from dissociative identity disorder at the time. Well, there you go. I guess you just got to let her go. Yeah, not so much. Yeah, prosecutors, they're not buying what she is selling through her attorneys, and they say that she was legally sane when she committed the murder. And in some phone calls that were played in court with Gannon's father, she admitted she accused the local sex offender of the crime. The guy, like I said, wasn't even in the country at the time. Well, it just keeps getting worse, more and more stories. And what, did she suffer from that dissociative disorder during the time that she was covering up and planning the disposal of young Gannon? Yeah. I, too, am not believing what she is selling. But remember, the defense has not gone yet. She is still given a presumption of innocence. We will afford that to her. And who knows, maybe her psychiatrist will be so compelling that at least one juror will say, I just can't decide. Next on the docket, a little Lori Vallow update. As we noted, we had to get back yesterday, but we were able to fly there and get back yesterday evening. But it was an interesting experience. Ada County there in Boise, very nice, clean city. It almost reminds me of almost Colorado Springs, the way it's kind of nestled right there up against the mountains. Lovely place, lovely people as well. Well, this morning, more Chandler, Arizona officers testified regarding the death of Charles Vallow. Now, the defense had no questions for these witnesses and basically said, we object to all of their testimony because this is 404B evidence. So I thought that this would maybe be a good time to try and explain this again. We've explained it several times, but the question still keeps coming up. Think about it. Lori Vallow has not been convicted of conspiring to kill her husband, Charles Vallow, with Alex Cox. Hasn't been convicted of it. But yet all that evidence is coming in against her, and we'll explain a little bit why. And I'm not sure the judge necessarily got it right, but we don't know, of course, because Judge Boyce has kept everything in private. His 404B rulings, the motions arguing for and against it on both sides, we don't have any information about it. I ask you, what is the big secret? All of this has been released in public information from the Chandler Police Department, but yet I don't think there's anything really new that's come out that the judge is making everything so secret. Anyway, 404B evidence is evidence of prior bad acts that the prosecution can introduce in their case in chief. Now, we'll talk about the federal rule, but most of the states are exactly the same. And it says the prosecution is able to introduce evidence of defendants' prior bad acts that are not charged in the instant criminal case. Okay? Now, although introduction of 404B evidence is not permissible to show the individual's criminal propensity or predisposition to commit crime, 404B is admissible for other reasons. So what does that mean? That's propensity evidence. Just because you have multiple convictions, you've done other bad things, we can't bring that in to say, look, they've done bad things in the past. They must have done bad things here in this case as well. Who knows? Maybe in this particular case, they're completely innocent and they got railroaded because of all the previous convictions. You just never know. So the 404B provides that prior act evidence is not admissible to prove the character of the person in order to show action in conformity therewith, but it is admissible for several other purposes. Specifically, 404B evidence can be admissible for purposes such as showing motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. Now, whether to admit 404B evidence is within the discretion of the trial judge, but it is subject to review by the appellate courts to say, hey, this was so prejudicial, it resulted in an unfair trial. Hence the reason why Lori Vallow's attorneys are objecting to each and every one of these witnesses as it relates to the death of Charles Vallow. So the judge has to decide their four-factor test that the court must consider in determining 404B evidence and whether it is admissible at trial. These factors come from a 1988 Supreme Court case called United States v. Huddleston, and then obviously the states have their own case law interpreting those as well. But to determine whether evidence is uncharged crime is admissible at trial, the court must consider evidence of the uncharged crimes was offered for a proper purpose and it was relevant to a disputed trial issue, and its probative value is substantially outweighed by its possible prejudicial effect against the defendant, and the trial court must administer an appropriate limiting instruction. Now, when you listen to the trial of Lori Vallow, when there is this 404B witness, the judge has issued a limiting instruction saying that, well, you can consider it for all these other reasons. Now, normally, courts are getting away from just saying, well, you can consider it for all of these. Now, at least where I practice in the state court, is that you must be able to articulate specifically under which subsection, not just say, oh, it's all of them, judge, motive, plan, scheme, absence of mistake, anything along those lines. So we'll see if the judge did a good job, but we don't know because we didn't get to see his order. I know, I keep going back to that, but it just drives me nuts. Never seen a case tried in chambers. So the 404B evidence in the case law is developed, basically saying evidence should generally be included unless there is an issue with one of the factors that we outlined above. Now, what is the limiting instruction? A limiting instruction is a jury instruction that the judge reads as part of the jury charge after summations, but before deliberations, that explain that the 404B evidence that was presented by the prosecutor was presented for only a limited purpose. For example, to explain motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident. The jury can also get that instruction throughout the trial, either before or after the witness testifies, sometimes both, depending on how often the defense wants it read. The jury will also be told that they are not allowed to consider that evidence as proof of any of the defendant's criminal propensity, right? So doesn't that make a whole lot of sense? Look at this crime that we think they committed for this particular reason, why it's coming in. But don't consider it as to whether they're guilty in this case. Just use it for, was this part of the preparation plan, absence of mistake? Sometimes it doesn't make a whole lot of sense, does it? So just because the prosecutor presents evidence that the defendant committed the prior bad act, and they're not charged in the instant indictment, the jury is not allowed to use these prior bad acts as proof that the defendant committed the crime in the indictment. And 404B evidence can be excluded if the court determines that the factors that we talked about before are not met by the prosecution when they file their motion. Remember, these have to be made pre-trial. The court needs to look at whether the probative value of the evidence is substantially outweighed by the danger of unfair prejudice, right? Makes sense. Hey, you're on trial for committing 3 murders. Let's talk about this other murder. Is that propensity evidence or common scheme or plan? Well, usually they have to be so related in the same manner in which they were done. The court's made their decision. Another appellate issue for Lori Vallow, I might add. I've always been a firm believer that if the prosecution had a strong case, they did not need any 404B evidence, because oftentimes 404B evidence can be confusing. It can mislead the jury. It's undue delay and wasting time in presenting a lot of cumulative evidence. All right, also who testified today? David Warwick, Melanie Gibbs' husband. And guess what? He got off to a rocky start. Apparently there's been an issue raised concerning his rule regarding sequestration and Mr. Warwick. As you may recall, witnesses were told not to watch or read about any testimony of any prior witness. That's right. So the prosecutor is going to ask Mr. Warwick what exactly took place. As you may recall, Mr. Warwick testified during Chad Daybell's preliminary hearing and said that he testified during the grand jury proceedings as well. Mr. Warwick says that he became sick 2 weeks ago and was not able to come with his wife, Miss Melanie Gibb, the day that she testified in court. And so while he was recovering, he just happened to listen to, 45 minutes of Miss Gibb's testimony and then realized that, I'm not supposed to do that. So then he immediately shut it off. Now, it came out that Miss Gibbs lives in Arizona and Mr. Warwick lives in Utah. They apparently have developed a distant relationship, and he says he has not talked with her about the trial as she needs her space. Now, Mr. Archibald argued that, hey, Judge, there's a reason we have rules, and we don't just to say, sorry, my bad, sorry about that. So he was accessing information on the internet. His motivation is irrelevant. He purposely accessed the information. And not only that, he accessed other articles about the people in this case, apparently. And there's a rule of sequestration, and we have those rules to protect the integrity of the court. Now, of course, the prosecutor argued that Mr. Warwick immediately told the prosecutors that he listened to Miss Gibbs' testimony and says that he's cooperated with the police all along in this investigation. He's testified in prior hearings, and guess what Judge Boyce did? He said, well, let me consider it. Didn't want it to interfere with the trial, but he wasn't going to hold Mr. Warwick in contempt of court. But he doesn't believe that it rose to the level of excusing the witness from the trial, excluding their testimony. Judge Boyce says that the conduct was, in fact, willful, but will allow the defense to liberally comment on Mr. Warwick's credibility in front of the jury, knowing that he was not supposed to listen to anyone's prior testimony. Wow. And of course, from what I can tell, I don't think the defense really cross-examined Mr. Warwick on that. I'm going to have to listen closely tonight. Hopefully you will as well. So Lori Vallow, Melanie Gibb, and Mr. Warwick apparently recorded this podcast in Lori's kitchen on a Sunday evening right before the death of J.J. Vallow. This is not anything new. We heard about it at the preliminary hearing. And Lori apparently told the group that Alex Cox, was babysitting J.J. at his place. About 10:30 p.m., Mr. Warwick said that he heard the front door open and he saw Alec Cox carrying J.J., who appeared to be asleep, with his head on his shoulder. Alec Cox took J.J. upstairs and put him to bed. Mr. Warwick recalls J.J. wearing shorts and a T-shirt. Now, Mr. Warwick also doesn't recall if Alex left, but he thinks the door opened and closed. J.J. was staying in Lori Vallow's room, and Mr. Warwick was staying in J.J.'s room. Mr. Warwick testified that in the early morning hours, Mr. Warwick says he had one of the worst nightmares of his life. He thought that it was very real. He said that Miss Gibb heard Mr. Warwick screaming in his sleep and tried to wake him up. Miss Gibb apparently said that she was going to get Lori to try and get Chad to come over to the house and give them a blessing. This was back in the early hours of the morning, sometime after midnight. Apparently, Melanie Gibb went to get Lori, but she didn't respond. The next morning, Gibb and Mr. Warwick went downstairs to say goodbye. Lori told Mr. Warwick that J.J. had an episode and climbed on the cabinets on top of the fridge and then knocked over the picture of Jesus Christ. Lori said she then called Alec to take care of him, and Warwick says he didn't see any signs that the cabinets were damaged and no marks on the fridge or anything along those lines. Mr. Warwick asked to see J.J. so he could give him a blessing if there was a problem, but Lori said that she would have Alec come and get him. Now, in cross-examination, Mr. Archibald asked if they started seeing each other, Melanie Gibb and Mr. Warwick, before their divorces were finalized. The prosecutor objected based upon irrelevance, but the judge overruled that objection, and Mr. Warwick let the world know that his divorce was being finalized, but Gibbs was complete. Now, Mr. Warwick says that he and Miss Gibb were interested in each other because they both liked religious topics. They also noted that he met Lori Vallow, Chad Daybell, and Alex Cox through religion. Mr. Archibald asked Mr. Warwick about the Book of Mormon conference he was attending in Rexburg, Idaho. Mr. Warwick said that the LDS Church did not sponsor the conference, but a person associated with Preparing a People, also known as PAP, is a private group not sponsored by the LDS Church, according to Mr. Warwick. And Mr. Archibald asked Mr. Warwick who was the designated audience for the podcasts. Well, Mr. Warwick says it was meant for the Latter-day Saints and was for education but not for money. He says the purpose of the podcast was to build faith. Mr. Archibald then began to question Mr. Warwick about dreams and visions. The prosecutor objected, said it wasn't relevant. Mr. Archibald said it goes to Mr. Warwick's credibility. The judge allowed Mr. Archibald to ask the question. Mr. Archibald was able to ask Mr. Warwick about his talk concerning visions and secret combinations in Washington, D.C. and Saudi Arabia. Mr. Warwick confirmed that he had such beliefs. And Mr. Archibald asked Mr. Warwick to explain the difference between a nightmare and a vision. Mr. Warwick says that a vision is when you're being shown things in the future, but you're not seeing yourself. Someone else is presenting it. Mr. Warwick says his visions come from angels under God. Mr. Archibald asked about the nightmare Mr. Warwick had at Lori's house, and Mr. Warwick says there was a lot of fear and darkness and no order to it. Mr. Warwick says he doesn't know where the nightmare came from, but it was adversarial. Mr. Archibald asked if that means the devil. Mr. Warwick says somewhere in that direction. Mr. Archibald asked if it was an angel of the devil. Could have been, Mr. Warwick replied. Mr. Archibald asked Mr. Warwick about the blessing he wanted from Chad while at Lori's house after the nightmare. Mr. Warwick says that Miss Gibbs wanted Chad to come over and give him a blessing, and he didn't necessarily want it either way. Mr. Archibald asked what a blessing from Chad Daybell would have done for Mr. Warwick, and he said, I would have hoped for peace, but it wasn't my idea. Apparently, Melanie Gibb was just trying to help, and after Mr. Warwick left Lori's apartment, he went to visit his son in Pocatello, Idaho, but did not see JJ. Mr. Archibald asked Mr. Warwick if he called the police. Mr. Warwick says no, because Lori was such a wonderful woman. Mr. Warwick says that they were teaching, and they didn't match the character of somebody bad. He saw no reason to suspect anything, and Mr. Archibald then ended his cross-examination. From what we can tell, we'll have to listen to the audio this evening, did he in fact go into the fact that he violated the court's order? And on redirect, the prosecutor jumped up and said, hey, the defense wants to ask about a bunch of dreams and visions. Let's talk about reality. The prosecutor then asked him to repeat what Lori told him the morning Warwick left. And he repeated that Lori said JJ was out of control and pushed over her picture of Jesus Christ that sat on the upper cabinets, and that Mr. Warwick saw no signs that anything had been damaged if JJ was climbing up on the furniture or the cupboards and the refrigerator in the kitchen. He also repeated that Lori said she called Alex to come and get him because she couldn't handle JJ.
As a pet owner, you want to give your furry friend the very best. That's why Baked in Colorado's CBD-infused dog treats are the perfect choice. These delicious treats not only taste great, but they also provide a wide range of health benefits for your pet. CBD has been shown to have many positive effects on dogs, including reducing anxiety, alleviating pain and inflammation, and improving overall wellness. Baked in Colorado's treats are infused with premium, full-spectrum CBD oil, meaning your pet will benefit from the whole plant extract. Not only that, but Baked in Colorado's treats are made with all-natural human-grade ingredients, so you can feel good about what you're giving your pet. They're also free from wheat, corn, and soy, making them a great option for dogs with food sensitivities. Baked in Colorado CBD-infused dog treats are the perfect way to support your pet's health and well-being. With various flavors, including peanut butter, pumpkin, and bacon, your dog will love them too. So why wait? Head to www.bakedincolorado.com today and order your dog a bag of these delicious and nutritious treats. Your pet will thank you for it.
And finally, our dumb criminal of the day. Please meet Mr. Anthony Hill. This young man from Florida was arrested for cocaine possession after police responded to a 911 call about a trespasser acting erratic and doing drugs outside of a 7-Eleven in Orlando, Florida. What is it lately? First we have food violence. Now we have all these incidents that take place at convenience stores. Oh, that's right. They've always taken place at convenience stores, haven't they? That's right. Well, needless to say, upon arrival at the convenience store, the police arrested Mr. Coleman Hill, smoking what appeared to be an illegal narcotic. Mr. Coleman Hill was allegedly displaying signs of narcotic impairment and also maybe admitted that he had been smoking some Molly. A search of Mr. Coleman Hill yielded a small bag of cocaine from a pant pocket, a according to the arrest affidavit, and he was arrested on felony drug possession and booked into the Orange County Jail, where he remains because he's been unable to pay the $1,000 bond. Now, Mr. Coleman Hill, let me tell you something. Hey, I think most people are of the mindset, if you want to do drugs, do drugs. Just don't do them in public and act weird and make people feel uncomfortable when you're at the 7-Eleven. Come on, man. Everybody wants to go to the 7-Eleven. Just go in, get your bag of peanut butter M&Ms, maybe a hot dog or something, maybe a hard-boiled egg, right? You don't need to be making people feel weird and uncomfortable. But why is it always outside of a 7-Eleven? Anyway, Mr. Coleman Hill, you are a dumb criminal of the day. Maybe when you get out, if you have a little time to sober up, you realize if you're going to smoke your Molly, do it at home. That's all we have for today. Thanks for watching. Make sure you listen for the trial testimony in the Lori Vallow case. We will get it up. Well, actually, Frank will get it up as soon as we receive it from the court. Have a wonderful day.